Is that something that you experienced yourself?
Objection as to relevance.
Sustained.
Is that something that the parents that you've worked with have experienced?
Objection as to relevance. It's not applicable to this case, Your Honor.
Sustained.
Your Honor,
She could talk about her experience with her own child, but
that was the first question.
she's not an expert that's been qualified in the court's view to talk about RAD as a psychiatrist or psychologist or a medical professional, but she's a mother who has raised a child with RAD, so I'm going to allow her to testify as to her personal experiences and what her opinions as a mother are, but you don't have to go much further to qualify her as an expert to talk about what would be tantamount to psychiatric, psychological, and medical opinions.
Judge, I'm not asking her.
Just ask your question. Re-ask it. I've ruled on it.
So you want me to re-ask it, or?
I want you to rephrase your question in a way that's consistent with my ruling and proceed.
Based on your personal experience as a mother of a child with reactive attachment disorder and as a person who has worked with hundreds of
Nope. The fact that she's worked with hundreds of people is not relevant to this case in this court's view. I'm going to allow you to talk about her experience as a mother raising a RAD child, because that's what's relevant, that the court finds marginally relevant for purposes of sentencing. So I will allow you to rephrase the question again, consistent with my ruling.
Based on your personal experience, did you find that kind of shame with raising a child with, or sharing what it was like to raise a child with reactive attachment disorder?
Yes, absolutely, and that's one of the reasons that I do talk about it and write about it, to try to bring awareness.
Why did you start your advocacy work?
Right after the Parkland shooting, I was watching the media and I was hearing a lot about how the mother saying, why didn't the mother get help? And also that the biggest argument in the media was that people needed more access to mental health care. And that was very disturbing to me because my son has been in 18 facilities over 8 years. And so I know that mental health is not there. And so the issue is we can give people access all we want, but if the mental health treatment for RAD is not in place, that's not going to help us. So I wanted to make that argument, and I also wanted to make the argument that sometimes parents do try to get help, because I tried to get help for years. It took me years to get help. And so I wrote an op-ed for the Sun Sentinel on that topic, and that is how I got started.
I want to talk a little bit about your experiences as a parent with a child with reactive attachment disorder. Now, you have a number of children, both adopted and biological, is that correct?
Yes,
And one of them was diagnosed with reactive attachment disorder.
that's correct.
When was that child diagnosed?
I'm not sure of the year, but he was 11.
So talk to me about, you said that when you adopt a child, when you personally adopted a child, you were not sort of prepared for what that might mean as far as any behavioral issues. Can you explain that to me?
Your Honor, I'm going to object as to relevance that this person's personal experience has to do with, relevant to the sentencing of this defendant.
Response?
Your Honor just stated that she was permitted to speak only as to her personal experience.
And another objection made as to relevancy, so just make your record for how you believe this is relevant.
Sure, Judge, I think it's relevant because first off, in a sentencing, there is leeway and the evidentiary rules are relaxed. I think that one thing that this court was not able to hear during the course of the trial, based on whatever the rules of evidence are in a jury trial and what a jury may hear, is what this experience is actually like. So actions, and particularly as it relates to the defense's first ground for downward departure, I apologize, I don't have the subsection in front of me, but it's essentially the language on provocation, is the court has to understand what it's actually like to walk in the shoes of a person who has a child with reactive attachment disorder. Additionally, I think it's imperative that the court understand that this is not some sort of fringe, and if this witness is permitted to testify, the actions that the Ferreters took, though inappropriate, were not fringe.
She's not going to be able to testify on the propriety of the actions that the Ferreters took.
I think she can testify as to what's available on the internet for parents with reactive attachment disorder, and hearsay is admissible in a sentencing hearing.
She's not an expert, though. She's a mother who raised a RAD child.
Sentencing, Your Honor.
Right.
In
Well,
sentencing,
if
hearsay is admissible.
If you're asking her to give a psychiatric, counsel, please don't interrupt me. If you're asking her to give a psychiatric, medical, or psychological opinion about what is an appropriate treatment for dealing with a RAD child, that's an expert opinion. I don't care whether it's in the main trial or it's in a sentencing hearing. You're asking this witness to provide an opinion that requires expertise that's recognized under the law that enables her to do that. I've indicated that I will allow.
That I got.
Who's that?
Wow.
All right. I've indicated I will allow you to have her talk about her personal experience and what she went through, but I'm not going to allow her to opine as to what the Ferreters, or Mr. Ferreter in this instance, should or should not have done. That requires an expert opinion that I don't believe this witness is competent to provide. And I'm certainly not going to allow her to provide medical, psychological, or psychiatric opinions. You can make your argument, respond for the record to preserve your rights on appeal, but we're going to proceed in accordance with my ruling that I've just stated on the record.
I understand, Your Honor. I would like to make one point. I am not trying to have this witness, who is a layperson, testify about a psychiatric opinion. I do think that a person can say, when you look on the internet, no one's saying that what they did was appropriate. That wasn't even the defense at trial. This witness will simply say that there is a lot of bad information out there and a lot of lack of good information for parents. This witness has testified that her own child went to 18 different facilities.
So what? So what? How does it connect to this particular case, unless you're going to put on evidence that the Ferreters tried time and time again to scour the internet to seek assistance? That, counsel, please don't interrupt me when I'm making my point, okay? Unless you're going to put on evidence that they sought out specific help on the internet and they got bad advice, the fact that she says there's bad advice or bad information on the internet, what's it relevant to? You got to tie it to my responsibility is to appropriately sentence Mr. Ferreter for the charges that he's been found guilty of by a jury. So this has to be focused on what his conduct was and what the explanation and justification for. I mean, this lady may have gone through hell and high water to raise her child with RAD, but there's no guarantee that her experience is even remotely close to the same as what Mr. Ferreter experienced, because I've heard no evidence that all RAD children react in the same way. So you're going down a path that I don't think I can allow you to go down too far, because this becomes a mini trial on another person's experience with a RAD child that at the end of the day doesn't give me any relevant information that's really going to assist me in determining what an appropriate sentence is. So that's my concern. I'm going to give you some latitude, but it's got to be reasonably tailored to how does it relate back to the conduct that Mr. Ferreter engaged in. So whatever point you want to make for the record, make it, and then ask your next question.
I will ask my next question, Your Honor. I believe I've already laid my record.